Bankruptcy at the time of emergency financial crisis. The current situation due to business interruption resulting from the corona epidemic has formed a unique social legal situation, as breaching the obligation to pay debts is no longer considered a violation of the provisions of civil and commercial laws. The complete cessation of debt repayment is no longer a legal reason for bankruptcy. The rules governing corporate governance are no longer in conformity with reality, and they are not expected to be applied in the way we were used to before the epidemic situation. It will be difficult to adhere to rigidly applying bankruptcy law to companies without regard to the current situation. Therefore, the United Arab Emirates amended its law to face the situation where companies stop paying obligations and debts without violating the law. The law added a new chapter applies only in certain exceptional cases that have a general impact on society as a whole. It is referred to in the law as the emergency financial crisis, which is a public condition that affects trade or investment. For example, an outbreak of a pandemic, a natural disaster, a war, etc. In order to control when such cases occur, and when these rules begin to be implemented, its cause and duration will be determined by a cabinet resolution, based on the minister's proposal. One of the most important effects of the amendment is the provision for postponing the debtor's obligation to request the opening of bankruptcy procedures. In an emergency situation like the one we are currently living in, many businesses stopped, and consequently, the income and revenues have stopped. Many companies are no longer able to pay their owed debts for a period of more than 30 consecutive business days. That is equivalent to about a month and a half. Or the company's arrival to what is known as indebtedness condition. That is a situation in which it appears that the debtor's funds will not at any time cover his outstanding obligations. Despite the legal obligation that the debtor must request a restructuring of his debts or bankruptcy and liquidate his business. Otherwise, the debtor will bear many effects in the event of his default in this duty. However, in cases of the emergency financial crisis, the law relieves the debtor of this obligation, provided that the cause of this suspension is a direct result of the emergency financial crisis. In this case, the debtor is no longer legally obligated to submit an application to open bankruptcy procedures during the period of declaration of the state of crisis, the duration of which is determined by a decision of the Council of Ministers, until the end of the period of the emergency financial crisis. Notwithstanding the foregoing, the debtor may submit a request to restructure his debts, or for bankruptcy and liquidation, during the emergency financial crisis, and claim that the loss of his business and revenue is directly related to the crisis. In this case, the court may accept the request and take whatever measures it deems necessary, including the conduct of the procedures without the need to appoint an expert or secretary, which reduces the procedures and costs, provided that the debtor proves that the disruption of his financial position or his debtor financial condition arose because of the emergency financial crisis. If the debtor submits a request to the court to initiate the procedures for restructuring his debts, or for bankruptcy, and the court accepts that request, he may accordingly request granting him a term not exceeding 40 working days. This will give him the chance to negotiate with the creditors and reach an agreement to settle his debts, and save his business from complete bankruptcy. Thus, both the debtor and his creditors will benefit from these new provisions. If the court accepts the request, the debtor must publish a summary of the court decision in 2 daily newspapers in Arabic and English. He will invite the creditors to negotiate with him to reach an agreement on the settlement within 20 business days from the date of publication. The place or the method through which the negotiation procedure shall be conducted must be specified in that invitation. The period for debt settlement should not exceed 1 year from the date of the court's approval. This includes the period for negotiation and the implementation of the debtor's settlement plan. In the event that an agreement is reached between the debtor and creditors, this should be recorded in writing, that includes electronic correspondence. The agreement is binding on all creditors if it is approved by the creditors who represent 2/3 of the value of the debts from those who participated in the negotiation procedures with the debtor. The court and creditors must be informed of the details of the settlement agreement. The court may reject the agreement if it becomes evident that it is inconsistent with good faith in implementing the obligations. This is a line of protection for the interest of the debtor and creditors, who have no share in enforcing decisions. In order to further guarantee the rights of creditors, the law permits any creditor who did not agree to the settlement agreement to object before the court within 15 working days from the date of notification of the settlement agreement. And the court shall decide on the objection within 5 working days from the date of submitting the objection. Its decision is final and binding on all creditors. If the debtor's bankruptcy application was submitted by the creditor during the emergency financial crisis, and the debtor's financial difficulty was a result from that crisis, in this case the court should postpone the request filed by a creditor for the bankruptcy of the debtor until the end of the emergency financial crisis. Furthermore, the court must decline to make a decision for conservatory measures on the debtor's assets, such as affixing seals on the premises of business and properties, if this was necessary for the continuation of the debtor's business and not to disrupt his production capacity. Thus the debtor will be in a better position to be able to pay off all the debts. However, if the assets are not related to the conduct of the debtor's business, then conservatory measures may be taken in that case. The law took into account that there are requests for bankruptcy that had already been submitted and accepted by the court, and the procedures were initiated previous to the occurrence of the emergency financial crisis. However, as a result of the crisis, the financial difficulty of the debtor worsened. In this case the court may take this situation into consideration and may decide to modify the extensions and periods of time as provided in the law to additional time limits, provided that this is necessary for addressing the direct consequences that the emergency financial crisis conditions imposed on the debtor's business. The court may also intervene to amend the debtor's obligations to fulfill its obligations under contracts it has adhered to, such as the possibility of terminating a lease contract on the property where the debtor carries out his business. If the debtor is a company that has ceased to pay its debts, and its directors dispose of the company's assets to pay the unpaid wages and salaries, which are paid periodically to the workers and employees of the company, where this is necessary in order to continue the company's business during the emergency financial crisis, such action will not be considered a violation of the law, and the directors of the board of the company will not be held liable. However, wages and salaries do not include the payment of allowances, bonuses and other incidental payments to employees. Furthermore, the members of the company's board of directors and managers are required to take the necessary care to update the company's accounts, particularly with relation to the consequences of losses resulting from the emergency financial crisis. They must act with care and good faith and to work in the best way that can serve the interests of the company and preserve its assets. If the court accepted the debtor's application during the emergency financial crisis, the debtor can obtain new finance, despite his difficult financial situation affected because of the crisis. To achieve this objective, the law granted the new obtained finance priority over other debts, and the creditor in the new finance will have the priority over any other ordinary debt fixed on debtor's assets that was obtained prior to the court's decision to commence the proceedings. Also, it is possible to obtain new finance by using the non-pledged assets of the debtor as security. Moreover, the new finance can be secured by the creation of a pledge on the non-pledged assets of the debtor which are appraised to overvalue the debt secured by the previous pledge. For example, if the debtor owns a real estate worth 1 million dirhams and it is already used as a mortgage for securing a debt worth 500,000 dirhams, the same real estate can be used again to obtain new financing. However, the new financing shall have a lower rank and priority than the first creditor, unless the first creditor agrees to give the new mortgage the priority. Finally, if the first creditor was a bank, then the same pledged asset can be used again to obtain fresh finance, even if the value of that asset is equivalent to the value of the secured debt. This should not exceed 30% of the value of the property. In this case, the court may issue a decision approving the new mortgage, and grant it an equal or higher rank than the outstanding pledge, if the aim of the new financing is to obtain materials or services necessary to continue the debtor's business.